What we will have here is now a presentation that will take its first steps from a practical question, I think. I mean, I will try and show how strongly the influence of the German historical school, Geschichtliche Rechtsschule, is in Sweden at least the 19th century when it comes to legal methodology and the sort of concept of what legal dogmatics could be in a positivistic approach. The general approach to legislation, to, I would say, law and reforms will eventually spill onto the question of the legal education and the needs mainly to educate civil servants and among all judges. So this theoretical approach to law that was put forward by Savigny and the others, the followers, Gustav Hugo, Friedrich Julius Stahl, the rest of them, was mainly to make something out of a practical problem. And this practical problem was witnessed in a law journal in 1869, for example, in Sweden, where a professor, or he was really a lawyer, was not a professor, called Levin, he stated that, in my free translation, steady and speedy growth of the population in combination with an expansion in this industrial market, in the capitalist market, leads to a number of new cases that county court judges, the first instant judges, are not able to cope with because they need more time that they have at their disposal, and they are not educated enough, one could agree here. And there were different solutions. So what we have from the point of departure here is a society that evolves relatively quickly. The industrialization is beginning. It's going to come much later to Sweden in reality, but it's starting. And what we have in Sweden at this time is a very old-fashioned code from 1734. It is legislation that was old already when it was issued, actually. It's called the last medieval code of Sweden, even if it was issued in 1734. And this legislation was characterized by a very casuistic way of writing law. That meant it pointed out certain situations in which the law should apply, and it was mainly constructed for a society of farmers, mainly, not for a modern society at all. That meant that the judges, the civil servants, had to try and adopt this code to new situations, and there were lots of lacunes, there were lots of gaps, of course. And the legislator didn't seem to be able to solve this problem, at least not at present. There was a solution because of influence from France in the beginning of the 1800s, huge influence from France, where there was put forward the idea of making codification à la française, code civil. But this idea was never really, it was actually abandoned in the 1860s. After a long period of trials, the parliament couldn't reach a decision, and we ended up with a small number of reforms in different areas, small new legislation projects, but no coherent code. And I think that that point of no return will be defining for the Swedish legal methodology in one sense, because as we don't have that codification, we ended up, as we will see, with something that may be envisaged by Savigny, that is a plurality of legal sources that at some point needs to be weighed together to form the dogmatic whole, that legal system that makes it possible, or at least they thought at the time, made it possible to both reach a conclusion to a case in every case that came up, and secondly, made it possible for legal science, that is the legal dogmatic branch of it, to describe what the legal system consisted of in terms of norms. So we have case law, legislation, legal doctrine, and also customs that should be included in this doctrine of the legal sources, rather than the code, mainly. This inability for the legislator and the legal profession, the judges, the civil servants, to actually achieve something in society reached in the 1860s also the universities, those behind the future lawyers, so to speak, the ones educating. And it was said in the parliamentary debates that the universities were lagging behind, they were not practical enough, they were very conservative. The universities were two at this time, one in Uppsala, which is the oldest one, founded in 1477, and one founded in the 1600s in Lund in the south of Sweden. So we had two universities at this time, and one we would have later in Stockholm. There came many suggestions for reforms at this point, how to reform the legal education, how to reform the education of the judges, and they were very much oriented towards non-academic studies in a sense, to make it even more practical, to make it very much more school than a university. And why was that? Well, you had at this point two branches of education. You could go on for 3 years, and you have very little legal theory, or you could go on for 4 years where you had some more legal theory, legal history, Roman law, and so on. But of course, both, and the thing was that both these branches or streaks were, you were able to enter into the civil service or even pursue a career as a judge. This meant, of course, that the 3-year-long education was favored by the students. The people in parliament, they wanted to reform along the lines that you should use the 3-year education, but you should have internship from the start. It should be focused on filling out forms, leading trials, be very much a practical thing, leading to the ability for the future judges to sort of hit the ground running. They would be able to cope this way with society, because law was much more a craft, something you did, than a science from their point of view. And it was even the most radical of these reforms put forward was to close down entirely the two universities and start a new university in Stockholm that would be closely oriented towards the practical and have where the students would have immediate access to the judicial branches, the administration of the state. The counter-argument, however, came from, not surprisingly, from the universities themselves and a new generation of professors who deemed this critique a bit unfair. They were, however, aware of that the education needed some reforms in order for the students to be able to cope with the present situation. And here we could see how the influence from Germany and from the ideas of the historical school maybe spills into the legal education. Because it is a parallel, the way the historical looked on legislation and the development of law and how they thought that legal education should be built up, I think, at least. Savigny had, as you know, in the famous Codifikationsreit with Thibault, said that we will not have a codification in Germany, at least not yet, along the lines of the French code. And why? Because he said that such a drastic measure to cope with, which was a problem, of course, different layers of legislation, different layers, and the inability to find the correct answer. It took an enormous long time and so on. But he said that such a drastic measure as a codification would sort of cut the law off at its roots. And these roots for him was history, the tradition, and it would make the population unable to recognize themselves in the legislation. So instead he wanted legislation to be a process, a political process where different aspects of tradition and so on could be preserved, but also, of course, history for him was something that must be evaluated. If we know where we come from, we also know where we're going, and we could evaluate these arguments throughout history and see if they are useful to us. Otherwise, they should be abandoned. They should be legal history. But you can never, in a positivistic approach, such as Savigny's at least, abandon the idea that law is, the reason we are here is for some historical choices, because of some historical choices. And as we shall see, that also spilled over into the legal education, because legal history was very much favored as one of the subjects the students should study, both as a subject itself, but they should also in their interpretation learn how to use these historical arguments. This is one of the canones by Savigny, the historical interpretation. He meant that history could be used in this sense to widen the wording of the law the wording of this casuistic legislation might lead to the feeling of a gap, of a lacune, but if you had a historical understanding of the word, you might see that the scope of the exact wording was a bit bigger than you could just see from the wording itself. And thereby, the judge would feel free and also comfortable with applying it to a new situation, thereby actually, in the interpretation, develop law, develop it, but in a controlled manner. So here we see maybe a difference from the French approach to interpretation, that Savigny actually acknowledged that the lawyer would develop law, but in another way than the politician, maybe, because it was a controlled way through the legal methodology. How controlled, we could of course discuss. He was aware that no judge is perfect, but he said anyway that this might at least restrain the legal profession a bit and benefit society. The other aspect that he stressed, of course, was the need for systematic or dogmatic understanding of law on a more, and that should be achieved through the knowledge of legal concept developed historically since the Roman law, of course, in the German sense. And thereby should, again, the judge feel comfortable to, in the light of a more abstract concept, adopt it, the casuistic legislation to more specific situations, claiming that this was actually the law that was applied and not something arbitrary. So these two approaches must bleed into the legal education, the dogmatic approach to law and the legal history. And as we see in Sweden, that was very much the idea. Because these two ideas would enable lawyers to cope with a society in evolvement, making a feeling of that law wasn't just lagging behind, but it was actually coping. When we got more elastic legislation later on, that would serve, this approach would serve as a boundary for the interpretation, thereby slowing down and maybe cut the arbitrariness down even more. So it will work both ways, both as an accelerator or as a damper, so to speak. As I've said, these ideas put forward by Savigny in Von Beruf, in System, and in other writings were directly or indirectly quoted by Swedish professors at the time. Carl-Olof Deldén was a professor of private law at Uppsala University, concluded generally that the only way to solve the present problems of legal practice was, as he said, a healthy coexistence of theory and practice in legal education. Other professors in private law, Professor Knut Oliver Krona, for example, stressed the same thing, and he also claimed in his writings to Parliament that he always tried to make the student both gain a theoretical understanding, a dogmatic understanding, a historical understanding, but also to have some practical cases to show the sort of counterbalance that we needed between theory and practice. I would say that the professor who maybe was most explicit in his admiration for the German historical school was the professor of private law, who was, I think, the predecessor of Oliver Krona, maybe his follower, Professor Ernst Victor Nordling, who in his inauguration speech as professor in Roman law, legal history, and jurisprudence, he stated that we are very grateful that the historical school has given us a truer understanding of the law, that she has inspired us and giving us the studies of law a new life, and lastly, that she has shown us how the past may shed light on the present. And that was, I mean, without reservation, the admiration for the historical school. This, as we will see, led to eventually the professionalization of judges on all levels. From having had learned judges only on appeal level and Supreme Court level, we have later on, at least from 1904 or the beginning of the 1900s, the mandatory program, 4-year master program for all students of law that wants to enter into both civil service and the judiciary. And there the theoretical aspects will be part of the curriculum. To make it longer had a practical aim, but it was the legal theory that was needed in all levels. Fredrik Skrivelius was a professor in Lund slightly earlier in the 1850s. He said, "Nowadays we demand from our judges an education based on the findings of science, and he must have undergone certain tests prescribed by law to pass." And this is actually, Skrivelius was quite a cheat, because he always took things from Savigny, wrote it in his own books without quoting him. So this is actually a quote directly from Savigny in System on the page 189, where he says, "Wir fordern vom Richter ein wissenschaftliches Rechtsstudium, über welches sich durch bestimmte Prüfungen ausweisen muss." So we could here see directly the sort of influence from the German historical school, both on a theoretical level, but also in the writing. I think I will conclude or end my speech there. Thank you very much for your attention.